The clerk will read the order of the day.
Government Business Notice Number 1, standing in the name of Mr Burgoyne to present the Water Amendment Aboriginal Water Reserves Bill 2025, Serial 21.
Minister.
Madam Speaker, I present a bill titled Water Amendment Aboriginal Water Reserve Bill 2025, Serial 21 and table the explanatory statement. Madam Speaker, I move the bill be read a first time. Madam Speaker, I present a bill entitled Water Amendment Aboriginal Water Reserves Bill 2025. The purpose of the bill is to amend the Water Act 1992 to improve the efficiency and administration of the Water Act and to ensure regulatory decisions can be made with respect to the Aboriginal Water Reserve. The bill introduces amendments to support the activation of Aboriginal Water Reserve to provide economic benefit to Aboriginal people and the Northern Territory. This Northern Territory government was elected on a clear mandate to rebuild the Territory economy, something that had all but come to a standstill under the previous Labor government. This government is committed to rebuilding the economy through a range of reforms that provide a strong foundation for growth with robust regulatory frameworks, world-class environmental protections and long-term certainty for business investment. The introduction of legislation for the Territory Coordinator and the removal of third-party merits review into the Legislative Assembly supports this commitment. And Madam Speaker, so does this bill. Water is an enabler for economic development. We use it for agriculture, horticulture, aquaculture, for mining and for onshore gas developments. And if we are to grow our territory, then we need to ensure that the water made available for economic benefits is used. For too long, access to the Aboriginal Water Reserve has been impeded by distractions, caused by ambiguous legislation and because the former Labor government was unable to find a solution to a problem of its own creating. A problem created because the former government did not implement its own policy. This bill corrects this ambiguity to make water reserved for Aboriginal economic development available for those who are ready to start doing business in the Territory today. An Aboriginal water reserve is a volume of water set aside for Aboriginal economic benefit. This water is allocated under a water allocation plan to Aboriginal landowners relative to the size of their land holding. The Aboriginal land must be greater than 1 hectare and it must have a certain relationship with the water resource being managed under a water allocation plan. How this relationship is described under the current Water Act is unclear, and subsequently, its interpretation does not align with the underpinning principles of water resource management in the Northern Territory, specifically that water is tied to land. When Aboriginal water reserves were introduced into the legislative framework in 2019, those amendments created ambiguity and operational challenges. This bill removes those ambiguities and reduces operational challenges. Specifically, Madam Speaker, this bill will do 3 things. Firstly, this bill makes clear the land that is eligible for designation to an Aboriginal water reserve under a water allocation plan. As I previously mentioned, water is tied to land under the Water Act. The land must have a certain relationship with the water resource being managed under a water allocation plan to which the Aboriginal water reserve applies. Not only must the land be more than 1 hectare, if the water allocation plan is managing groundwater, then the groundwater must be beneath the land for that land to be designated as land to which an Aboriginal water reserve applies. And for the owners of that land to be assigned a share of that reserve in the water allocation plan, this has been the practice for water allocation planning to date. The amendments proposed in this bill will make that practice clear under law. Secondly, the bill creates efficiencies and removes elements of the legislation that have created a distraction to the water allocation planning processes. The current requirement to consult specifically with land councils regarding eligible land before it is designated in the water allocation plan duplicates consultation processes already undertaken as part of the development of those plans. Eligible land for the purpose of Aboriginal water reserves under the Water Act. This includes Aboriginal land under exclusive native title, land declared under Aboriginal Land Rights Act, and freehold land owned by registered Aboriginal corporations. Through existing water allocation planning practices, all groups are equally consulted with the opportunity to participate in water advisory councils and through public consultation processes. The Department has also been making great inroads into increasing Aboriginal participation in these planning processes. Madam Speaker, it is the Departments of Land, Planning and Environment that has the skills and capabilities to complete the task of identifying the land of the particular tenure and size and its relationship with the water. The Department holds and administers Northern Territory land title information under the Aboriginal Land Rights Act and freehold land, and has established relationships to be able to draw on the national data sets for native title land. The Department is the expert on land titles in the Northern Territory and is responsible for generating and managing the spatial information that shows where our groundwater resources are and where our surface water flows. The Department is best placed to identify eligible land and has existing consultation practices and responsibilities that ensure this information is available to all landowners before a water allocation plan is declared. Finally, with these amendments, we are stepping aside from attempting to prescribe a one-size-fits-all consent process for Aboriginal people to access their Aboriginal water reserve. The amendments proposed under this bill will allow eligible Aboriginal landowners to determine how and who gives consent for a person to apply for a licence from the reserve. We are creating this opportunity by removing the requirement to establish regulations that prescribe the class of people who can give consent and the process that must be followed in determining consent. Government does not impose on any other individual, group or company how it goes about deciding to apply for a water extraction licence, and we will not do this for Aboriginal landowners. To enable this autonomy, this bill proposes that the controller of water resources be satisfied that an application for a licence has come from an eligible Aboriginal person, or if that eligible person so wishes, someone whom they have made an agreement. This government respects Aboriginal decision-making practices and traditions and is removing itself from prescribing a process for consent that already exists within tradition and through existing practices. These amendments will provide the space for Aboriginal landowners to decide and apply their own processes for determining who can apply for a licence. The controller of water resources, the independent statutory decision maker, in deciding an application for a water extraction licence in relation to an Aboriginal water reserve, will need to consider who the applicant is and whether they are an eligible Aboriginal person as specified under the water allocation plan. How the controller satisfies himself of that may vary depending on the land tenure, and I will be encouraging the controller to develop some guidance that explains this. Ultimately, a decision to grant a water extraction licence rests with the controller of water resources, and they are directed in their decision-making by the Water Act. In the case of Aboriginal Water Reserve, after considering who has applied for the licence, the controller must consider several other factors that include the relevant water allocation plan, water availability and impact on other water users. It is through this process that the controller considers the impact of taking water. Applying for a licence does not guarantee a licence will be granted. And equally, consent to apply for a licence from an Aboriginal landowner does not mean a licence will be granted. Once an application is accepted, the assessment process commences. It is through this public process that the impact of taking the water is considered, and it is through this process that all people who may be impacted by the take of water also have an opportunity to make submissions for the controller's consideration in making a water extraction licence decision. These amendments clarify the criteria for granting a water extraction licence with respect to an Aboriginal water reserve. Madam Speaker, ultimately, this bill makes amendments that will improve the Territory's water resource legislative framework and support economic development for Aboriginal people in the Northern Territory. There will be some Aboriginal landowners that are ready to reap these benefits now, and there will be some Aboriginal landowners who are not. But these amendments create an environment that facilitates Aboriginal landowners ensuring they can take advantage of available economic benefits when the opportunity arises and when they are ready to do so. I am pleased to commend this bill to honourable members and table a copy of the explanatory statement.
The question is that the bill be read a first time. Those of that opinion say aye. To the contrary, no.
Aye.
I think the ayes have it. The clerk.
A bill for an act to amend the Water Act 1992.
Minister.
Madam Speaker, I move that the second reading of the bill be made in order of the day for the first Assembly meeting after 28 days have elapsed.
Member for Gwadja.
Thank you, Madam Speaker. Madam Speaker, I move the following amendment, that we omit all the words after that and insert the following words. The bill be referred to the Legislative Scrutiny Committee for a report by the 7th of May 2025. Madam Speaker, the Environment Minister has just come into this parliament talking about the importance of water and how important it is for people to have a say. We've had the government continue to say that they've met with people. Well, let's remind the government, meeting with people and organisations does not constitute consultation, Madam Speaker. The Northern Territory was leading, and I pick up on the laughter.
Order.
I pick up on the laughter of the government, thinking that by meeting with people, they are consulting with people.
Okay. Can you just pause, Member for Gwadja?
Too lazy. Too disrespectful.
The member for Gwadja will be heard in silence. Please continue.
Madam Speaker, meeting with organisations and with people does not equal consultation. The significance of this bill...
Okay. People are going to be on a warning if they continue to interject.
Point of order, the clock has continued to click and it's taken about 1 minute due to the interjections.
Okay, we'll adjust that. The Deputy Clerk said that she did pause it. It is paused now. I'm happy to give you 20 extra seconds. Member for Gwadja, please continue.
Madam Speaker, we've seen in this parliament this morning the interest in this important piece of legislation, a bill before Parliament, Madam Speaker. It is important. Water is absolutely important to Territorians, and every Territorian should have the opportunity to have a say and to absolutely be able to put a submission forward to the Legislative Scrutiny Committee about this matter. On a national level, the Territory has been leading in the national Closing the Gap targets on strategic Aboriginal water reserves, and you hear this morning the Environment Minister coming in here, eroding that, wanting to water that down, Madam Speaker, without any consultation. We've heard how disrespectful the Environment Minister is to traditional owners by not consulting with them on other pieces of legislation, Madam Speaker. It is absolutely important, and if the government have nothing to hide, then they would send this to the Legislative Scrutiny Committee to deliberate on, to hold a hearing, to invite public submissions from the community, from Aboriginal Territorians who will be affected by this piece of legislation, Madam Speaker. It is crucial that the voices of Aboriginal Territorians is heard and is able to be represented in this place. Not allowing them the opportunity to put a submission in about the bill that is before Parliament is shameful, Madam Speaker. Not allowing organisations that represent Aboriginal interests and their land to have the opportunity to have a say is disgraceful, Madam Speaker. But that is what you get under the Environment Minister, Madam Speaker. He doesn't want to consult, he doesn't want to talk, he doesn't like scrutiny when it comes to his poor performance on the environment, Madam Speaker. This is important. This is too important to not send to the Legislative Scrutiny Committee, because this is an opportunity, because almost half of the Northern Territory is Aboriginal land through the Aboriginal Land Rights Act and through native title. You are effectively shutting out a significant portion of Territorians. Aboriginal Territorians make up over 30% of the Territory's population, and to say to them, we are not willing to hear your voices, your concerns, but importantly, your suggestions on how this bill could be strengthened, how this bill could be amended to be in the best interests of Aboriginal Territorians. They do not want to hear it, Madam Speaker. They do not want to afford that opportunity to have that level of input, to have that ability to hear from them around where changes can be made, Madam Speaker. They are shutting down Aboriginal Territorians.
Order.
Look at yourself in the mirror.
Madam Speaker, this is an important issue. We can hear already in the chamber how important and how passionate people are about this. Imagine all the people outside, how interested and passionate they are about their rights. Water rights is everyone's rights, and everyone deserves to have the opportunity to have a say about it. I'm sure if this was certain other stakeholders that the government are in bed with, they'd be having public hearings because they'd want them to come and they'd want them to say how great and amazing and deadly the bill is. But when it comes to vulnerable people in the Northern Territory, this government do not give a damn. They do not want to hear the voices. They do not want to hear the criticism. But also, Environment Minister, this is an opportunity to hear from Aboriginal Territorians how they could help you make your bill better than what it is. Better, helping open and unlock the potential for business. But they don't want to hear it, Madam Speaker. I absolutely move the amendment that this motion calls on the government to refer this matter to the Legislative Scrutiny Committee.
Are there any other speakers? Member for Nightcliff.
I'd just like to stand in support of this amendment. I would urge those on the other side of the chamber, please don't let your feelings about Labor get in the way of doing what's right for all Territorians. When you talk to any traditional owner, any person out on country, they always say water is life, water is country. It is always the number one thing that they talk about when talking about protecting country. Water is sacred sites, the underground water, the surface water. I don't know how any of you are going to be able to look any countryman in the eye and say you're doing the right thing by them if you don't let them be involved in this process by sending it to the Scrutiny Committee. This is serious. Water is serious, and if you truly stand by the laws that you're making, you would let it go to Scrutiny Committee to be scrutinised and to let those Territorians be involved in this process. Their voices matter, and shutting their voices out of this is really not good enough. I honestly don't know how you're going to look any of them in the eye. Please, First Nations voices, the voices of community, remote areas, water is everything. Let them have a say in this. Let them come along on the journey. Put this before Scrutiny Committee, please.
Chief Minister.
Thank you, Madam Speaker. And I couldn't help but speak this morning listening to the righteousness of those opposite. This is the same people, the member for Guoja, who was a senior minister, Attorney General in a failed Labor government that scrapped the Scrutiny Committee, Madam Speaker. And I actually find it incredibly offensive to 50 years of the Legislative Assembly when those opposite, as ignorant as they are, can stand up in this Parliament, Madam Speaker, and say that the parliamentary process isn't proper and does not allow for consultation. It is an absolute misleading statement. It is a farce to say that the normal parliamentary process doesn't work, because you know what, Madam Speaker? It has supported the Westminster tradition for hundreds of years across dozens of countries and the world. It works. It is a tried and tested system of government, opposition leader, a system of government. It absolutely works. And you know what we did? We made it even better, Madam Speaker. So I'm not going to stand here and tolerate the garbage from the other side for their own political games because they're too lazy to do their own job. It is absolutely proper parliamentary process that bills be tabled in Parliament, that they sit on the table, in which case this will sit on the table for around 6 weeks, Madam Speaker, and then it will come back for debate, in which time every single Territorian, every single person who doesn't live in the Territory, every single person who lives in the world, for all I care, can have a look at it, can provide their feedback to, wait for it, Madam Speaker, their elected representatives who are meant to be doing their job. So if you care so much about this, get out there over the next 6 weeks and do your job, member for Nightcliff, because you can sit here and shake your head at me all you like. That is the role and responsibility of a member of Parliament. So newsflash, everyone. the Westminster system works. Scrutiny committee is there for an additional process. And at the end of the day, the very people who came into this parliament and scrapped it because they were running and hiding from scrutiny cannot point the finger at the government that brought it back, Madam Speaker, that brought it back. And so we will not be accepting the member for Gwoja's tokenistic amendment.
Take your seat. Everyone's being very rowdy this morning. What's your point of order, member for Karama?
With the hearing Chief Minister.
I think you are absolutely correct. I've allowed some latitude. It's been very exciting this morning, but we will now listen to the Chief Minister's contribution in silence. Thank you, Chief Minister.
Thank you, Madam Speaker. And so, as I said, we won't accept the member for Gwoja's tokenistic amendment. And so the opposition leader, Madam Speaker, is yelling out shame because she believes the parliamentary process doesn't work. You should not be a member of parliament if you do not believe the parliament works, because that is what you are saying. What you are saying opposite is exactly that. The process doesn't work. What you are saying is that it does not allow for the community to have a voice and have their say, in which case you should not be a member of parliament because it fundamentally undermines the integrity of the entire institution. Your argument is rubbish, nonsense, absolute nonsense. Okay? The process has been there and is there for a very, very good reason. So go and do your job, put it in your newsletter, reach out to your electorates, because that's what we'll all be doing. We'll be going to our electorates, seeking their feedback on it, discussing it as a team, and giving speeches in Parliament about that feedback. And then guess what, Madam Speaker? Do you know what happens at the end of all of that? We vote on it. And that's how we allow the voices of Territorians to be properly and appropriately heard in the Parliament. That's the actual process. And you know what? It would be amazing, Madam Speaker, if they actually did their jobs and came in here and voted on what their communities wanted, because we most certainly do not see that from those opposite. So, Madam Speaker, I think I've made my point. The hypocrisy from the other side is not lost on everyday Territorians. They are sick and tired of it. What they want is Labor to look themselves in the mirror and have some reflection on the result that was dished out to them by Territorians because of the way they failed for 8 years to govern the Northern Territory. And so now there is an opportunity to do things differently. We will not apologise for going against the status quo. We will not be taking leadership lessons from Labor. We will not be following anything that Labor used to do because it didn't work. You literally broke the Territory. You put Territorians on their knees. And you know what we're doing, Madam Speaker? We are building the Territory back from the ground up. That is our commitment to Territorians, and we will stop at nothing to deliver on that for everyone.
Leader of the Opposition.
Thank you, Madam Speaker. And we see a very unhinged Chief Minister responding to a very simple amendment that's been put forward by the member for Gwoja, Madam Speaker. We know that the CLP was so proud to announce to everyone the return of the Scrutiny Committee, and it is something the Territory Labor opposition absolutely welcomed, Madam Speaker. We welcomed it. Yeah, from opposition. No secret, Labor lost the election. We all know that. But now we're seeing the processes that the Chief Minister has outlined when it comes to the Westminster system and the process of scrutiny by the public around what government does is absolutely important when it comes to the Westminster system. And we agree, Madam Speaker. We're in opposition. We understand the importance of that. We've heard from the member for Nightcliff, who is a Greens member, the importance of that. And we know that Territorians want to have a say, but more importantly, Madam Speaker, they want to have their voices heard, particularly when it comes to legislation of the Northern Territory Parliament, which, guess what, Madam Speaker, affects all Territorians, not just the 17 members of government, not only the 4 members in the opposition, not only the 4 crossbenchers that we see here in our Territory Parliament make up for this term, Madam Speaker. We absolutely respect and, again, we welcome the Scrutiny Committee, but what we are seeing, Madam Speaker, from the CLP government, again, is a horrible, bad pattern of behaviour where they cherry-pick what they decide as government. They've got the numbers, everything's going to pass that they put forward. We're not naive, we know how the system works. but they are now cherry-picking what they can publicly be scrutinised on. And that, to me, Madam Speaker, is the most dismal display of respect when it comes to the democracy of the Northern Territory. The Chief Minister herself outlined the Westminster system. We are all here because of it, Madam Speaker. And then we are here to adhere to the processes that the government has put in place for the new sessional orders. And again, we are seeing picking and choosing of which legislation goes to be scrutinised. How crazy is that, Madam Speaker? The government has the numbers. We know from a bad history that they don't even listen to their own government-dominated committees. So they've got to do what they're going to do, but let's pretend that the government for a minute wants to be a good government, that the CLP actually want to listen to the people of the Northern Territory, not just the 17 electorates that they represent, but all of the electorates, because guess what? The Northern Territory government governs for the whole of the Northern Territory. So let's remind the CLP of that, Madam Speaker, in this opportunity. And what the Minister has displayed today is talking about, but not any slither of evidence about talking to and understanding the people who are directly affected, in this case, in this particular legislation, Aboriginal Territorians who have the rights for those very important Aboriginal strategic water reserves. This was groundbreaking legislation and policy in the Northern Territory, Madam Speaker. No one else in the country, other jurisdictions, Madam Speaker, were looking at the Northern Territory and the amazing and complex work. This is not simple, Madam Speaker. This was complex work that was led in the Northern Territory to provide these opportunities of strategic water reserves. And the Close the Gap refresh targets include inland water targets. And the Minister, you would think, Madam Speaker, as being, if hopefully a responsible Minister, the Minister who's brought this before a House, the member for Breitling, has showed no sense of responsibility when it comes to listening to the work of the Northern Territory, but the national expectations about water reserves and inland water targets for Aboriginal and Torres Strait Islanders. Absolutely no regard with this piece of legislation that has been introduced before the House, which is why, Madam Speaker, the member for Goyja, on behalf of the Territory Labor Opposition, has made the simple amendment, that's all we're debating here at the moment, Madam Speaker, the simple amendment that we send this very important piece of legislation that will resonate across the Northern Territory to allow anyone and everyone who wants to have input onto this legislation, again, that will be legislated for all Territorians, but particularly to scrutinise and either support it or not support it, or indeed, Madam Speaker, blow me down, maybe improve what the government's doing. But they do not want to act in a way that shows they are credible, they are responsible government who will listen to Territorians.
Member for Blaine.
Thank you, Madam Speaker. Madam Speaker, I rise to support this bill and to oppose the amendment by the member for Goyja, because those opposite failed Indigenous Territorians when they were in government. Domestic violence increased by 82%.
Member for Blaine, could you just pause, please? Please be seated. Opposition Leader, for the most part of your contribution then, you were heard in silence. Can you please give the same respect to the member for Blaine? Thank you.
Thank you, Madam Speaker. And I will continue that domestic violence under the watch of the previous Labor government increased
Oh, sorry. Member for Blaine, please take your seat. Member for Goyja, what's your point of order?
110 relevance. This is about a motion to send something to a scrutiny committee about Aboriginal strategic water reserves.
Look,
don't laugh and disrespect Aboriginal people, member for Nelson.
No, please
Goyder.
sit down. That is bordering on disorderly. Member for Goyja, we will take a deep breath and we will listen to each other respectfully. The member for Blaine has just started his speech, 29 seconds into it. Please listen to what he has to say. Thank you.
And I pick up by the interjection by the opposition leader alleging a glass straw, and by the number of interjections this morning, I think it's obvious who has the glass straw.
Opposition leader, you're on a warning.
So, as I was saying, under the watch of the previous Labor government, domestic violence increased by 82%. When I visit bush communities, the number one thing that elders talk to me about is bringing back their local community councils. They still, to this day, feel disempowered by the actions of the previous Labor government that took away their local community councils. But luckily, this government is here, and the member for Barkly is in charge of bringing back those community councils and giving back local determination to those people and community. The second thing they talk about is housing, which again, the member for Barkly will be sorting out. The third thing they talk about is economic development on country. Economic development on country. Water is a key part of that. That's why I support this bill that the member for Breitling is bringing, and I oppose the amendment by the member for Goyja, because we need, Indigenous Territorians need economic development on country, and this is a key part of delivering that. The previous government created confusion by the legislation they passed, which made it very difficult to do business under this regime. So thank you, Madam Speaker. I commend this bill.
Member for Fong Lim.
Madam Speaker, I rise to speak to the process, not the substance of what we are discussing here. And I think it's, this is coming to a head repeatedly, discussions regarding scrutiny, what should and shouldn't be sent to a scrutiny committee. The fact is we're playing fast and loose with the Westminster system and what we should and shouldn't do. The only part that is embedded into our process is that we provide the bill, we provide time for people to consider the bill, to consult widely in whatever form they determine consultation to be in the wider community. Now, 28 days have been provided. This isn't a bill on urgency. There is ample opportunity for everyone in this House to go and to solicit feedback from people in the wider community. Now, it's important to note that a scrutiny committee is not a substitute for this legislature. It's an additional mechanism. It's an additional mechanism, and it's a mechanism that didn't exist under the original. It's a mechanism that didn't exist under the original Westminster system provisions. Now, this is foreshadowing debate to some extent, but not that anyone knows. Later this evening, I will speak to the Scrutiny of Legislation conference that members of the Legal and Constitutional Affairs Committee attended together. At that conference, we learnt a lot, and I will table documents speaking to it later tonight. But what I want to point out is that scrutiny committees don't all function the same way everywhere, and scrutiny committees are not all functioning as ours does. But at least we have a scrutiny committee now. At least we have a scrutiny committee now. The reality of it is that we have gone from having nothing to having something. Now, if the opposition and the crossbenchers are dissatisfied with the government's prerogative to choose when to send things to the scrutiny committee, then that is a subject you should take up separately. You should challenge the sessional orders. You should mount a campaign. You should seek to change the terms on which the scrutiny committee operates. But right now we have sessional orders. We have a process, and that process is the process that we must respect. I'm a believer in process in this regard. This government at least has had the decency to put a scrutiny committee back in place. My personal position, and I'm happy to declare it, is that I would prefer for the scrutiny committee to be, able to address things as a de facto standard, as is the case in many other jurisdictions. But if that were to be the case, we would need a legislature with a lot more resources than we have at the moment. Because what I don't want is for our scrutiny committee to just become a pointless forum for protest. And that's essentially what it will be if we continue down this track. Madam Speaker, I implore all of the members of the House to think carefully about how best we can utilise the mechanisms at our disposal. I understand the intention behind the amendment, and I don't disagree with the intention behind the amendment, which is to provide people in the community an opportunity and a voice to speak on a very important bill. I think it is a very important bill, and I'll be consulting widely with my community about the bill, and I'd encourage you all to do the same. And I'd encourage you all to bring back your collated data to the chamber in 6 weeks' time from now so that we can systematically go through it. The question of whether you're heard to your satisfaction or not is a matter of process and a matter of our democratic process. I'm not rejoicing in the democratic system that we have here, it is essentially a winner-takes-all system. But the reality is that the people of the Northern Territory, in the most recent election, did elect a government of 17 of us. And the 17 of us now are collectively doing the best we can to progress the Northern Territory socially and economically in a balanced way. Now, not everything we do will be of your liking or your choosing, but it will ultimately be a matter for the people to decide whether or not they are satisfied with our direction and our governance. Now, I am all for having a discussion about our processes in here, how our committee systems work, how our motions work, and frankly, the standard of conduct in this place, which I still generally find pretty disgusting. But it's up to all of us collectively to do something about that. Yeah, it's up to all of us collectively to do something about that. This motion is not going to pass, and rather than bemoaning the motion not passing or politicising that it hasn't been sent to a scrutiny committee, concentrate on speaking for the people you represent, bringing those voices back to the chamber and fighting your corner in that regard. And we will do the same. I believe the intention behind the bill is sincere. I don't believe the Minister for the Environment, Lands and Planning is, is out to nefariously destroy the Northern Territory.
Your time has expired, Member for Fong Lim.
Thank you.
It's also past 10:30. I'd ask the photographers to leave the chamber now, please. Thank you. Member for Johnston.
Thank you, Madam Speaker. I also want to speak in support of this motion. As a member of the Scrutiny Committee, our job isn't just to see what people like or what people don't like. It isn't just to go and talk to our constituents, which of course we will all be doing, and we will be bringing what our constituents think back to this House, and I hope it will be heard by the chamber. But the job of the Scrutiny Committee is much more than that. The job of the Scrutiny Committee is to consider whether a bill referred to it has sufficient regard to the rights and liberties of individuals, including, and there's a whole list of what that bill looks like. Many of those items are very significant and relevant to this particular bill. So we have a job. We're here to help the parliament. We're not here to stand in the way of things. I rejoice that the Scrutiny Committee came back. You know, I think that it enhances our system. I agree with the member for Fong Lim that the baseline, as is in many other jurisdictions, should be that every bill, there's a default for bills to go to the Scrutiny Committee. We would need far more resources to be able to do that well here. But we shouldn't be having to argue in a parliament as unbalanced as this. We shouldn't have to argue for when there's a bill that is going to be of great importance to people, is clearly of great significance to people, including in this chamber. We shouldn't have to argue that we can do more work to make sure that that bill is as good as it's going to be for the whole Northern Territory. That should be where the default is, I think. So I strongly support this motion. I strongly support that. We know not every bill can go to the Scrutiny Committee, but a bill which has significant impact on the rights and liberties of individuals. Part of the terms of reference for the Scrutiny Committee are that we have to make sure that bills have sufficient regard to Aboriginal and Torres Strait Islander tradition, which this bill goes directly to. So I strongly commend this motion. I think it will enable the bill to be better. I think it will enable all of us in this parliament to do our job better. Thank you, Madam Speaker.
Are you speaking to the amendment, Minister?
I believe so, Madam Speaker.
Member for Breitling.
Thank you very much, Madam Speaker. It is really important to look at what has been said this morning in regards to the amendment and why it needs to be adopted. And I'll pick up on many of the things that members have said this morning in regards to their contributions. The NT does have nation-leading legislation as it relates to water allocation and the Aboriginal Water Reserve. Those opposite put in place many of those laws in which we are now speaking to. The problem with those laws, Madam Speaker, there is 60 gigalitres, and this is really important for those opposite to understand, that currently sits in the Aboriginal Water Reserve allocated for Aboriginal people that cannot be utilised right now. It cannot be activated. It cannot be utilised due to their failed legislation previously. What this is seeking to do is to amend that legislation that those opposite so proudly speak about, Madam Speaker, to ensure that it can be activated for Aboriginal people. It is so important that we understand that. 60 gigalitres of water. Water is life. Water is important in the Northern Territory, and it is an economic enabler. We are seeking to activate that resource for Aboriginal people. People will be able to have a say, Madam Speaker, and what has been overlooked today by many members that have given contributions is that Aboriginal people are a part of those water allocation plans and processes before we even get to having an Aboriginal water reserve, Madam Speaker. There is a huge amount of work, processes that can last for years before we get to this process where we have an Aboriginal water reserve for people to be able to access and utilise however they see fit. Now, Madam Speaker, there will be a lot of conversation over the next month in regards to this legislation. But today, what we are seeking to do is to strengthen legislation that is before us to ensure that everyone can access that water, that Aboriginal people can access that Aboriginal water reserve should they see fit, that they can benefit themselves and their communities through this enabling resource, and that they can get on with doing what they see fit to make their communities a better place to live. Madam Speaker, we do not accept the amendment, and I move that the question be put.
The question is that the amendment be agreed to. Those of that opinion say aye. To the contrary, no. I think the noes have it. Division is supported. I call a division. Thank you. The results of the division are 6 ayes and 17 noes. The noes have it.